Certainly any decision that involves reinsurance coming from the House of Lords deserves particular attention. But I think if you took a poll of reinsurance practitioners, either in the U.S. and those either on the company level or lawyers or arbitrators, I think most people would be very, very surprised at the result in Wassa versus Lexington. For the basic reason that it really offers no commercial solution. There's always the expression that bad facts often lead to bad law. I think this is probably a situation where you have a difficult underlying factual circumstance which led to a result that probably, at least from the U.S. perspective, is really not consistent with principles of follow the settlement and follow the fortunes. In Wassa, you had a situation where you had a facultative certificate which was issued on a either back-to-back or a following form basis, which really should have covered the liabilities that the underlying cedent may have accrued. In this instance, it dealt with first-party property liability for environmental cleanup for Alcoa. And that particular decision was a bit controversial in and of itself. You had a situation where the cover was certainly to follow in all respects, except you had a situation where the governing law was different between the certificate and the governing law of the underlying cover. But there was nothing in the factual record to indicate that this was something that was bargained for between the parties. This was simply one of those situations where the governing law was merely referred to in both separate contracts. So you have a situation where, from the underwriter's perspective, they were going to follow the settlements in all respects in this facultative cover. And what happened was you had a ruling by the Washington Supreme Court, which was contrary to how an English court would have arrived at the question that was posed in assessing these environmental liabilities. Certainly from the cedent's perspective, it did all it could to litigate those underlying issues and minimize its liability. Yet from the reinsurance perspective, the result was that the cedents were left with no remedy in this situation. And if you look at it from a practical effect, they say, well, here's this result. What could have happened from the underwriting perspective to avoid this scenario? You really are left with very little, other than perhaps in situations when you're dealing with risks internationally, you have to be clearer as to what governing law is going to apply. And you have, I'm sure out there, you have a lot of situations where you have facultative covers or even treaty covers where you're supposed to, where it's intended by the parties to those contracts to have a situation where the reinsurer is clearly going to follow the settlements and the liabilities that the cedent may have. Yet you may have this disconnect in governing law, which was not contemplated by the parties when they signed the agreement, certainly not bargained for, had no cost in the premium, and you may have this disconnect. Those situations have to be evaluated and to see whether or not, at least from the U.S. cedent perspective, are they exposed to liability or potential scenarios where they may not be able to recover if a UK reinsurer decided to advance the same argument that Wassa did against Lexington. I think for companies that do business in the UK, I think they have to strongly consider how their wordings are to be used in terms of what governing law is going to decide the liabilities under that scenario. Certainly, in facultative, following form or back-to-back reinsurance, what should happen is that the reinsurer should be bound to follow the liabilities of the cedent irrespective of whatever law the cedent is going to have to follow. It would make no sense for parties to bargain over law that either hasn't been decided or may be decided in a manner that's unfavorable to a cedent in the scenario that that Lexington found itself in the Wassa case. So I think on a going forward basis, to avoid these scenarios, and again, this was probably a scenario, clearly a scenario that was unforeseen by both the cedent and reinsurer. In doing business abroad, the governing law has to be made clear, and the governing law of the arbitration should be made to follow that of the governing law of the underlying treaties. And in that way, you will avoid a scenario like what happened in Wassa versus Lexington, where you have what I think all would agree would be this anomalous type of result for follow the settlements and follow the fortunes.